welcome to Immigration Talk with renowned attorney Mayra Joli.
Conditional permanent residency. If a person is the spouse of a U.S. citizen or a permanent resident, and the marriage occurred less than 2 years before the alien spouse is admitted as a U.S. permanent resident, then the permanent residency status is conditional. The alien spouse is given conditional resident status on the day he or she is lawfully admitted to the United States on an immigrant visa, or received an adjustment of status where he or she is allowed to stay in the U.S. Removal of conditions of permanent residency. Immigration laws presume that the marriage that occurred less than 2 years before the alien spouse was admitted as a U.S. LPR, which means legal permanent resident, are marriages entered into solely for the purpose of acquiring immigration benefits. The petitioning citizen or resident and the conditional resident must prove that they did not get married to evade the immigration laws of the U.S. First, a U.S. citizen or a permanent resident and his spouse must apply together to remove the condition on the spouse's residence. They should apply during the 90 days before the spouse's second anniversary as a conditional resident. Usually, the expiration date of the alien spouse green card is also the date of his second anniversary as a conditional resident. If they do not apply to remove the condition in the time, the alien spouse could lose conditional residence status and be removed from the United States. If the conditional resident has been battered or abused by his U.S. citizen or permanent resident spouse, the alien may apply to remove the conditions of his permanent residency at any time after he or she becomes a conditional resident, but before the removal from the United States. If the marriage becomes not viable, that is, the couple is separated or no longer shares a household, the petition to remove the condition of residence shall not be denied, provided that the conditional resident can show that the marriage was entered into in good faith and with a genuine desire for a marital relationship and not solely for immigration purposes. If the couple is divorced, the alien may also apply to remove the condition of his or her residency at any time after he or she becomes a conditional resident, but before he or she is removed from the United States. If the alien spouse's child received conditional resident status within 90 days after the alien spouse did, then the child may be included in the alien's application to remove the condition on the permanent resident. However, the child must file a separate application if the child received conditional resident status more than 90 days after the alien spouse did.
And that is it for this session of Immigration Talk with attorney Mayra Joli. To schedule a consultation with Mayra, please feel free to contact her office at 305-722-2828 or via email to schedule a consultation. Her offices are conveniently located at 1221 Brickell Avenue, Unit 1210, Miami, Florida 33131. Till next time.